Good morning, everyone, and welcome to Compliance and FTC Regulations, a Primer. Thank you so much for joining us today. First, I'd like to introduce our guest. Bill Rothbard is here with us today, and he's with FTC Ad Law. Bill has been an attorney for 30 years now and has spent many years at the FTC in a variety of roles, so he's well experienced within our industry. He speaks at many different conferences and has written many different articles on the subject. And most recently, he was at Affiliate Summit, which is where we met, and I learned all the wonderful information that this gentleman has. So officially, it's the law offices of William Rothbard, and we'll share this information later if you want to contact him after the event. My name is Janine Crooks, and I'm the Publisher Acquisition and Development Manager at AWIN US. We are an affiliate network based in Baltimore in the US, and globally we are based in Berlin. So welcome to our event today, and let's get started right away. So we're going to begin with an FTC overview on this. And Bill, I'm going to kind of turn it over to you. This is going to be a general question and answer sort of.
Hello?
Can you hear me there? There, I can hear you now.
Hello?
I can hear you, Bill. I can hear you.
Hello?
Oops. Let me let him know.
Hello?
So,
Nice.
there we go. Okay. So what we'd like to do is just kind of make this a more casual sort of event. Bill is going to kind of discuss some of the major ideas that we've got, and then we'll be able to answer any questions that you may have. Please feel free to go ahead and ask questions along the way. Just type them and let me know as you're doing that, and we'll see if we can't answer them for you, or any that are left we will do at the very end. So here we go. So for the FTC overview, Bill, would you like to begin now? Can you hear us there? Okay, well, let me go ahead and get started on this because Bill and I had the opportunity to talk about it quite extensively before this began. One of the things that we are covering today is that compliance is absolutely required. So it's very, very important that you do this. It's required for both advertisers and publishers, and the FTC treats endorsements and testimonials similarly. So there's a lot of people that have wondered in the back kind of whether or not they absolutely have to be compliant. And they do. The answer is yes, you do. And you've got to do it within certain guidelines as well. So 3 principles that guide everything on here is that it must be truthful and not misleading, that generally expected results must be clearly and conspicuously disclosed, and the connection between the endorser and marketer must be disclosed. So there's a couple of really key points in there that are part of that. The clearly and conspicuously is a huge one. So Bill, are you able to join us? For some reason, he's having a few problems with his microphone. Let's see here. Okay, so let's go ahead on to the second slide here. One of the things that you need to know is that it must be truthful and not misleading. So some of the things that are really key about this is that the testimonials and endorsements must reflect typical consumer experience. So if you're writing about something, say you're writing about, some sort of a weight loss thing, which is part of the reason why the FTC has gotten so intense on this, is that a lot of people would say, you can lose 20 pounds in 1 week. Well, that's not the case. That's not typical. Yes, some people are going to do that, but the vast majority of them are not going to lose that kind of weight. They may lose 2 pounds. So you need to reflect the typical consumer experience. Bill, why don't you try calling in instead? Because hopefully that is going to be able to. Oh, there we are. That seems to be working. Bill, can you say hello again? Bill? Okay, he's going to keep working on that and hopefully call in and be able to join us on this. The disclosure.
Hello?
Okay, we can hear you. Can you hear us? Okay. Let's see here.
Hello? Hello?
Oh.
Hello? Hello?
you now, Bill, but if you're on speakerphone, can you take it off?
Can you hear me?
Yes, but with a lot of feedback. So that wasn't.
Can you hear me?
Yes, now I can hear you.
Hello?
We can hear you, Bill.
Denise, can you hear me?
Yes.
I don't understand this.
Okay. Well, we will get back to Bill in just another minute. So anyway, to continue from here, paid bloggers, social influencers, and reviewers can be liable for making false claims. Now, we did just have a question pop up here. How are agencies responsible for this? Part of what we're dealing with agencies, officially you are not the representative of the merchant. It's the merchant's responsibility. But nevertheless, the agency is responsible to their client for, protecting them. So part of that's going to be, kind of in your specific.
Janine, can you hear me?
Yes. Okay, but there's an awful lot of echo, Bill.
Hello?
Okay, we can hear you.
Okay.
Great. You want to pick it up
Sorry.
from here?
Sorry about that.
No problem. I'm going to just let you continue from here.
Can you hear me? You can hear me. Okay. I'm not sure I can hear you.
I'm going to mute everybody else so we don't get any feedback. Oh, there. Now it seems like it's working well. Okay, great.
So can you hear me?
Yes.
Okay, good. Sorry, everybody, for the technical difficulties.
We've still got plenty to cover here, so we're going to put you to full work, Bill.
Have I been introduced?
Yes.
Okay.
So right now what we're doing was talking about the FTC overview on the disclosure guidelines. So the first one being it must be truthful and not misleading.
Correct. The FTC enforces its statute, Section 5 to be exact, which prohibits unfair and deceptive acts or practices in commerce. And it also enforces several trade regulation rules under its authority. One of which is relevant to this audience is the endorsement and testimonial guides, which require disclosures of various types. The most important one being that if there's a financial connection between the endorser, which can be a blogger or a reviewer, an influencer, and the advertiser, it must be disclosed. The guides also apply to claims that endorsers and testimonials make. There may be a misconception in the affiliate community to some degree that affiliates, which include reviewers, bloggers, influencers, are not liable for misleading claims that they make. That's not true. Both the advertiser, the merchant, and anybody making claims on the merchant's behalf potentially has liability for making false or misleading or unsubstantiated claims. An example of a misleading claim might be that an affiliate says that perhaps based on information that is received from the advertiser, that a claim is that a person can lose, let's say, 30 pounds in a month or two. If that, in order for that claim to be lawful, it has to be substantiated by a clinical study demonstrating that the average person using the product will lose 30 pounds in a month or 30 pounds in 2 months. If there isn't a study or the study doesn't support that claim, then the affiliate cannot make the claim, or certainly cannot make the claim without an adequate disclaimer that the claim is not typical. So as the slide says, claims that are made by an advertiser or by an affiliate have to be typical, and if they aren't typical, there has to be an appropriate disclaimer.
Okay.
And as the next bullet says, the disclosure has to be of the generally expected results, of the average results. If the advertiser doesn't know what those results are, and doesn't have a copy test showing that the reasonable consumer won't expect the claim results to be typical, then technically the advertiser or the affiliate should not make that claim at all. But certainly, at the very least, if you're making a claim that's not typical and you don't have data that shows what the generally expected results are, then you at the very least should have what's called a safe harbor disclaimer, indicating that the claim is not typical, it will vary, and being as specific as possible about how the claim was not typical.
Okay.
And as I said, and as I've already said, bloggers, influencers, reviewers can be liable for making false claims.
Right, right, which is something that's so important for everybody to understand. Let's go
as a general rule, the FTC more often than not will bring an enforcement action against the advertiser for failing to make sure that its affiliates or influencers disclose any financial connection or any other necessary disclaimers. Mm-hmm. And the FTC has brought cases like that in the last few years, but significantly this past year it brought its first case against an actual social influencer for failing to comply with the disclosure requirements. Wow. And it has sent out warning letters to dozens of social influencers in the past year or two, putting them on notice of their obligations to disclose any financial connection with an advertiser. And I think it's fair to say that that more cases against influencers directly, not just their advertisers, are coming down the pike in the coming months and years.
Well, that's something to be prepared for. One of the things that someone did ask is, I mean, we've said that the advertiser is at risk and the publisher is at risk. Now, often there's also an agency that's involved, whether it's a PR agency, perhaps it's an outsourced performance manager that's managing the affiliate program. What kind of risk are they facing by this?
Well, it's interesting that that's a very timely question, because just this month, and I wrote about it in my FTC Ad Alert blog this month. The FTC just announced a settlement with an ad agency called Marketing Architects, which is a major radio TV ad agency. It's not really an internet ad agency, for assisting its client, the advertiser, in making unsubstantiated weight loss claims. The agency created the spots and bought media for the spots, so it was directly involved in the creation and dissemination of the advertising. And because the claims were not substantiated, the FTC sued and settled not only with the advertiser client but with Marketing Architects. And the consent order going forward makes Marketing Architects liable not only for misleading or false claims made by itself in the future in its own behalf, but makes it as liable for misleading claims made by its clients as a client itself, unless it can show that it did not know and should not have known that the claims were unsubstantiated.
Okay.
So ad agencies as well as any other third parties that are assisting merchants in making advertising have liability for making sure that the claims are truthful and substantiated.
Wow. Okay. Okay, let's move on to point number 2. So the generally expected results must be clearly and conspicuously disclosed. And so what I tried to do here was share information on what clear means. Because, in legalese, you've got to spell everything out. So it's supposed to be in plain English, not in legalese. Place as close to the claim as possible. The language must be understandable by the reasonable consumer. No links between the disclosure and the claim. Not at the end of the post or in the sidebar or just linked to a separate page. And Twitter and Facebook should include something like #ad before the affiliate link. So does that give us good guidelines here on just what clear means?
It does, and the highlighted term unavoidable is really the operative term. The FTC interprets clear and conspicuous to mean unavoidable, to mean literally unavoidable, meaning that a disclaimer is not clear and conspicuous unless it is unless it can't be missed, by the average consumer. When I was at the FTC, when I was at the FTC years ago, the chairman of the agency, for whom I eventually worked as a special assistant, actually hired a consultant, a linguist who was a consultant and a specialist in turning legalese into plain English, to assist the FTC in writing its rules and regulations and guidance in plain English. Mm-hmm. And so the FTC expects not only itself but the people that it regulates to make disclosures in plain, understandable English. The most important concept that advertisers and affiliates need to understand and really implement in their practices is the clear and conspicuous standard. It's not defined more specifically anywhere. It's really a case-by-case judgment. Mm-hmm. But the FTC has provided a lot of guidance on what clear and conspicuous means, and it sort of goes by what are called the 4 Ps, which are prominence, placement, presentation, and proximity. And I can review some of the factors that the FTC applies in deciding whether a claim is clear and conspicuous. But for a lot more information, folks can go to the FTC's website and look at the FTC's.com disclosures guidelines, which were issued 3 or 4 years ago. That provide not only an explanation of the meaning of clear and conspicuous in the 4 Ps, but also provides, I think, over 20 examples, concrete examples of what is or is not considered to be a clear disclaimer in the online social media context. And there's also a good amount of marketing document guidance at the FTC's website, specifically geared to folks who are working as bloggers and reviewers and influencers in the digital realm.
Very good. Well, because part of what I see here often, and as I'm talking with different bloggers and website owners, a lot of them, don't want to put something at the top of their post. But I think that that's really, based on this, your best place to put something, because then it is unavoidable. And then, the first link is your affiliate link, wherever that is. I mean, I don't think that we want, that what the FTC doesn't necessarily want is this giant clump of copy right before your link. But there shouldn't be any links between your first, between your disclosure and the first affiliate link. So.
That's correct. The FTC doesn't say that a disclosure has to be at the top, in the middle, or at the bottom of an ad. But it does say that generally speaking, a disclosure is more likely to be noticed at the top of the ad than at the bottom of the ad, and certainly it doesn't want links or multiple links between the endorsement and the disclosure. So there's a lot of common sense that goes into deciding what's clear and conspicuous. Mm-hmm. And I think a good exercise is for an affiliate to put herself or himself into the shoes of a consumer looking at its post or its review and saying, if I were a consumer, would I be likely to see this disclosure? Right. And if the common sense answer is no, then perhaps you need to make it more prominent.
Well, I know one of the things that I just noticed, I had someone point this out to me, and it just made so much sense, is that she put her disclaimer in the sidebar and thought, so it's just right here, so easy to see. But when it was viewed on mobile, it moved down to the bottom because it was a responsive theme. And so, all of a sudden it went from, adjacent to completely avoidable. So, I think best practice then is to put it at the top of your post. So that's
best practice. And also that raises another important point, which is that marketers, including affiliates, need to understand that their disclosures have to be clear and conspicuous on all platforms, and that the disclosure that's conspicuous on a desktop may not be conspicuous on someone's phone. And so they should they should try to make their pages, their posts, mobile ready as well as desktop ready, so that and make sure that their disclosures are as clear and conspicuous on the smaller devices as they are on the larger devices.
Very good. So now the next part we wanted to talk about was the connection between the endorser and marketer must be disclosed. And this is really kind of a big thing. Any form of compensation creates a material connection. So if you are given a freebie so you can review it, if you're given, cash so it's a sponsored post, any kind of an in-kind payment as well as a commission are also other items that are in there. And the reason why I really wanted to kind of emphasize the in-kind payment is that, in one of the documents that I saw come through from the FTC, that was even if you were swapping links. Because you're getting something from them, they're getting something from you, that is a material connection and needs to be revealed. So, I think that that's important for people to kind of be aware of, especially if you're, really actively pursuing a link swap, then you might want to do something to reveal that you are trading links with someone and, just disclosing it. It doesn't have to be in front of every single kind of post like that, but just in some way disclosing it. Now, at least here, the next point, though, is the one where I feel like the FTC is at least being nice, where you must disclose once, but you don't have to do it every time a product is mentioned. So that means, if you're doing some sort of a roundup article and you're talking about 5 different barbecue grills, you don't have to put your disclosure in 5 times. So I like that. Right? Do I have that right?
Basically, the test for whether or not any form of compensation constitutes a material connection that needs to be disclosed is whether or not the reasonable consumer would give weight to that information in judging whether or not the endorsement is independent or not. So, for an example is if someone is reviewing an app and the reviewer is given free access to the app, mm-hmm. that may not be a large enough incentive or element of bias to be given any weight by the consumer if the consumer knew that. Okay. But if the reviewer was given not only a free app but was given free product, mm-hmm. or services that are promoted in the app, then that clearly would constitute compensation that could affect the amount of weight that the consumer would give the endorser.
Okay, that makes sense. I'm glad to get that little caveat in there.
But it's important to emphasize that while affiliates, any third parties who are reviewing or promoting a product or service are liable not only for non-disclosure of a financial connection to the advertiser, but also for the claims that the affiliate is making to make sure that the claims are true and substantiated. The most important takeaway for this audience from the FTC's endorsement guides is the requirement to disclose clearly and conspicuously any financial connection that it has with the merchant. Okay. That's the most important part. And again, if at the FTC website, there's a business document for which probably has dozens of questions that the average blogger or influencer or affiliate might want questions to from the FTC, mm-hmm. and it's very practical and very example oriented. So I really encourage folks who are listening to look at that afterward or whenever you have time to go to ftc.gov. Okay. and look at that document. It might answer a lot of questions, but we won't have time to answer today.
Right. And so our final point on here was just if the publisher purchased the item, disclosure isn't required unless they are, for example, part of the affiliate program and there's a potential of earning commission. So,
Correct.
so there's a couple little caveats there. Let's talk a little bit now about the actual disclosure process and what's needed. So you can't just say this post contains affiliate links or this post contains affiliate links, click here for more information, which is on a whole different page. And my understanding of that was, according to the FTC, it's because consumers can't necessarily or don't necessarily understand what the word affiliate means. You know, and I mean, while to us it only means one thing, you know, in our industry, outside of our industry, people are kind of, you know, they've got 12 different definitions of the same term. So therefore, you know, it should say something like this post contains affiliate links. If you click through and purchase something, I may receive a payment. Or I received this item for free from valuepetsupplies.com in order to review it. Should you purchase it, I may receive a commission. All opinions, however, are mine.
That's a good summary. Yeah. So the question is not whether whether folks in the industry understand what a term means, but whether the reasonable consumer will understand what a term means. And the FTC has made it very clear in their guidance that the term affiliate links by itself would not be clear enough to inform a consumer that the affiliate is being compensated for his promotion of the product.
Right.
So
right.
Again, it's case by case and common sense oriented, but the question to ask yourself always is, whatever terminology I'm using to make clear, to disclose that I have received some form of compensation for reviewing this product, will it be clear enough to the average consumer? Will it be clear enough to my wife, to my girlfriend, right. to my friend, to my daughter, to my son, to the average person on the street?
Right? Does grandma get it? If
yes.
Gets it, you're
yes.
good, right? So I know at least that would be the case in my house. Now, one of the things, though, that you and I discussed back at Affiliate Summit is that sometimes it can also be fun. So as long as it explains that the publisher is somehow being compensated, it should be acceptable. You know, something that indicates that there's some sort of financial connection. So, you know, what we wanted to share now with the audience is that it's okay to use your examples. So here are some examples of people being a little more creative with their thing.
Sure.
So
absolutely.
It contains affiliate links, which means if you click through and buy something, you could help support my Starbucks habit. This post contains affiliate links, so if you click and buy something, I may get to take my family out for dinner. I think that this is fun too. This post contains affiliate links. When you buy something through them, I earn money to buy more electric trains, but the opinions are my own. Since this post contains links to websites selling these items, if you buy something, I may earn rent money. And finally, Value Pet Supplies gave me this cool cat toy for free so Fluffy could try it out. If you buy one, we may earn some catnip money, but all opinions are Fluffy's and mine. You know, so I mean, just kind of stuff like that. You know, if your blog has a lot of personality or your website has a definite kind of character that's there and talking to people, it's okay to reflect that in your disclosure as long as your disclosure is displaying that you could get money for this or some sort of compensation. And I think that that's what we're showing in each one of these examples, is that there is compensation that could take place, you know, but it doesn't have to be all stuffy and formal if you don't want
it. Absolutely. And humor also can be, can be a very effective marketing tool. So you not only through humor are complying with your legal obligations, but you're also perhaps making a better connection to your consumer, and which will lead to more clicks and more conversions.
Right, exactly. So, you know, so we want to try and let people know, because so many people are worried that if they put this clump of copy at the top of a post or at the top of a page or something like that, that, you know, the consumer is going to read it and totally get stopped and not go any farther. But it doesn't have to be that way. It can have some personality to it, the same way your site reflects your personality. Okay, what we wanted to do next was kind of do some individual examples. So one of the things here was on Facebook. It's important to disclose the relationship with advertiser in plain language, and hashtag ad is acceptable. Is that correct?
It's acceptable. It's important as we go through these examples to keep in mind that the disclosure not only has to be in plain language, but it has to be, again, placed and so prominent as to be unavoidable.
Right.
Can't be missed. So in a space-constrained platform such as Facebook, sometimes certainly Twitter, maybe Instagram, hashtag ad, hashtag sponsored, hashtag paid ad are acceptable and comply with the clear prong of the clear and conspicuous test. But it also has to be conspicuous. It can't be, it can't be in smaller font than the surrounding text. It can't be lighter than the text, so that it sort of blends into the background. And maybe missed. It can't be surrounded by graphics or other text that distract and take the consumer's attention away from the disclosure. So it's very important to keep in mind the conspicuous part of the test as well as the clear, plain language part of the test.
That makes complete sense. Well, one of the things that I wanted to show here was kind of the difference between posts and ads, because there is a little bit of a difference, and so many people that we work with are doing ads on Facebook as well. So the post, which contains information and has something like a personal opinion and is usually deep linked, should actually have hashtag ad in it. And I grabbed this one because it's somebody that I know and work with a lot. And in this particular case, I called her last night and said, by the way, you need to put #ad in here for this one, because she was doing it as a post rather than as an ad. So if they were to do it someplace like we've got get your personalized scratch off map from our affiliate here, would that be an appropriate place where they would do hashtag ad and then put that before the link? Would that be acceptable?
I think so.
Okay. Okay, good. So then it can be incorporated without having to scream at the top, because it's still there and easy to see.
It can be incorporated as long as it stands out adequately.
Right. Okay. But now, if you're doing something like you're doing an ad, which is this here from Alaska Airlines, and it's obviously sponsored. So Facebook went ahead and said sponsored. Because you're buying an ad and it's going to show up as sponsored, you don't have to, in addition to that, put in hashtag ad.
Correct.
No additional compliance language is required.
Right. The term sponsored is acceptable to the FTC as a disclosure of the financial connection. The term, the abbreviation spons, like SPSONS.
Yes.
Which you see sometimes, probably is not clear enough.
Okay. Good to know. So now moving on to Twitter, everybody's.
And also, if you go back to that slide for 1 second.
Yes, sure.
You see how sponsored is in a it's in a lighter.
Yes, in a lighter
color than Alaska Airlines.
Yes.
So I mean we're focused on it, and so we notice it, but the average consumer perhaps may not notice it because it's so much lighter than the rest of the text and colors in the ad. So
Facebook might not be quite as compliant as they should be.
Correct.
Okay, good to know. Good to know. Okay, on to Twitter. Here you want to make sure that you've got a hashtag ad before the link. So this is a really good example of it, where you can just do something like that. It's just kind of right in there. So it's revealing to somebody what it is, and yet at the same time, it's before the link. It's nice and close. You can see that it's an ad. So, I think this one is compliant, right? We're in good shape on here.
It's probably compliant. It would definitely be compliant if hashtag ad was bold-faced.
Okay. That's
or perhaps even in a larger font.
Okay. Yeah, well, Twitter kind of is one size fits all, so
Yeah, I mean, you're looking at this and you're reading the post, and hashtag ad is right there in the middle, but it doesn't stand out from the surrounding text, which arguably could make it less conspicuous than it should be.
Okay, that sounds fair. All right, so let's take a look quickly at Pinterest, because that's one as well. So we need to get a hashtag ad before the link. So depending on where you're going to put that link in here, and you've got so many different choices, you should make sure that you've got #ad before that. So once again, that's enough to be compliant, correct?
Correct. Again, if it's not at the very top and separate from the product names, you might want to consider highlighting it in some way, bold-facing it, putting it in a larger font.
Or all caps or something like that?
All caps, right, just to make sure that stands out.
Okay, okay. Well, that's good to know. So there's some options that you've got there. Just for sure, no matter what, make sure it's there. Okay. And then our final one that we wanted to go through from a social media standpoint was Instagram. So, basically Instagram doesn't officially permit direct links and descriptions, but, there are some alternative methods that people do employ. So a lot of times they'll have a landing page specifically for Instagram products, where they'll use, or they'll use their affiliate link as their primary link for a limited period of time. So, if you're doing that, you need to put #ad in there by your primary link. Now that there's cookieless tracking, that's going to make things a little bit more different, or more interesting now, rather, because there's not a cookie that's dropping. So for somebody who's doing cookieless tracking, where they're basically just offering a coupon ID or something like that, how are they supposed to incorporate it? Is it #ad as well in whatever copy they post?
Mm-hmm.
Okay.
Yes. Also, another point for Instagram disclosures that the FTC has emphasized and actually included as an example in its warning letters to social influencers is that, I think this is correct, that in an Instagram post, only the first 3 lines of a post appear on the page itself, and you have to click more to read the rest of the post. And the FTC requires that the disclosure be in the first 3 lines of the post and not in the more part that you have to click on to see.
Oh, that's a very good thing to know. Okay.
Yeah, I mean it's so important to FTC that was the example that it put into the warning letters to social influencers to make them aware of on this particular platform of what they consider to be an important aspect of disclosing properly on Instagram.
Well, that makes sense. So just make sure that if there's any clickable location, whether it's your picture description, your bio, whatever, that you've got #ad. Since we have started talking a little bit about cookieless coupon tracking, where they're going on something like this. So, where it's just something that's showing up in some places where you might not normally see an affiliate link like Reddit, then they should probably put one more hashtag in there, #ad.
Correct.
Okay. That's good to know because cookieless tracking is growing now within the industry. That's one more thing to do. Okay. Well, great. So I think we've covered just about everything. It's time to move on to questions now. So if anybody has any questions, please feel free to email them to me. Or to just enter them right in the message system here, and I'll be glad to do that. But the reason why I mentioned email is that I had a couple of people email me some questions in advance because they weren't going to be able to join us right away. So one of the things that they were asking me about was Amazon, because Amazon has a very specific phraseology, here is what you will use. And it didn't seem like it was necessarily consistent with what the FTC has said. And, so I've got some publishers that are coming to me and they're like, which one do I follow? What Amazon says, what the FTC says, where do I put it? Because Amazon hasn't necessarily been specific about that. Yes, and I know it's different that a network is actually talking about Amazon, but I'm doing it because we want this to be of most benefit to all of our publishers that are out there. People work with.
So Janine, can you explain a little more what Amazon's
about what
policy
Amazon
is?
Saying? Sure, let me go ahead and get that right here, because they've got very specific language that they use. So let me grab that here for you. So what Amazon actually tells them to say in a very specific way is, let's see here, I've got it. And they will actually kick you out if you don't do it the same way that they want it to be done. So they will tell you, sorry, just grabbing it here. Let's see. You must clearly state the following on your site or any other location where Amazon may authorize your display or other use of content. Except for this disclosure, you will not make any public communication with respect to this agreement or your participation in the Associates Program. You will not misrepresent or embellish our relationship with you, including by expressing or implying that we support, sponsor, or endorse you, or express or imply any affiliation between us and you or any other person or entity, except as expressly permitted by this agreement. So, that's what they're saying. But, while they've got the official terminology, it doesn't tell them whether it should be before links, where it should be located on the page. And so a lot of bloggers have gone back to putting it on the bottom of the page, but basically, they've got that kind of information.
As long as an Amazon affiliate complies with those requirements, then it's not prohibited from further complying with FTC requirements.
So what they're telling them to say is, we are a participant in the Amazon Services LLC Associates Program, an affiliate advertising program designed to provide a means for us to earn fees by linking to Amazon.com and affiliated sites.
So you're saying that Amazon requires that disclosure, but doesn't specify where and how it should be made. Is that right?
Exactly.
Okay. Well, okay. So
a lot of bloggers, for example, have gone back to putting it at the bottom of their post, or they throw in a phrase and say, click here and you can get all the information.
No. The latter certainly doesn't cut it. Where the affiliate, where the disclosure should be made on the page, again, depends. Again, is governed by the FTC's endorsement and testimonials guide. Okay. In the guidance that they've given. So the disclosure can be at the bottom of the page as long as it will be unavoidable in that place. So if it's a long page and the consumer has to scroll down to the bottom to see the disclosure, that isn't sufficient. The FTC really disfavors placing disclosures below the fold, so to speak, so that the consumer has to scroll down to see it or click on a hyperlink to see it. So it can be at the bottom of the page as long as it's not a real long page, as long as the bottom is above the fold, and as long as it's in large enough font and with adequate contrast to the background to stand out and be easily seen. Okay. If it isn't, then it should be at the top of the page or someplace else that will be more noticeable.
Okay, that makes sense, because the affiliate who sent this to me was kind of chuckling, because she said, I know Amazon will kick me out if I don't follow their terms, but I'm a lot more scared of the FTC than Amazon.
Oh, yeah. Well, it's certainly not desirable to be kicked out of the Amazon program, given Amazon's market power. But Amazon won't sue you for that. They won't try to freeze your assets or make you pay money to the government for violating the law. So it's important for the affiliate to comply with both, but understand that complying with one with Amazon by simply putting the disclosure somewhere on the page won't comply with FTC's rules unless the disclosure is clear and conspicuous.
Well, it's good that you just brought that up, because the other question that has just come through was, what are some of the consequences for non-compliance? So it sounds like getting fined.
Sure. So the FTC has a range of remedies, which range from sending out a warning letter, which it has done to social influencers, to sending a demand letter for information substantiation, evidence of compliance to anybody that it thinks is misleading consumers, to sending what's called a civil investigative demand, which is like a subpoena to somebody that the FTC suspects to be misleading consumers, to at the very other end of the spectrum, investigating someone without that person's knowledge and compiling enough evidence in the FTC's opinion to then go into federal district court, without notice to the defendant, to the target. It's called ex parte, and getting a temporary restraining order and an asset freeze against that party.
So they can
allegedly violate the FTC's laws or regulations.
Wow.
In this context, social influencers, affiliates, by and large, unless they are doing really egregious stuff, making crazy claims, failing to make any disclosure, becoming pretty big, pretty visible, generating a lot of traffic and so forth, or working or driving traffic to a merchant that's under investigation by the FTC, probably doesn't have to worry about the most draconian remedy, which is the TRO asset freeze, but still has to worry about receiving not only a warning letter, but a demand letter or a CID, and being found to be in violation and being required, as the social influencers who settled with FTC last year did, or the companies that have been sued and settled for failing to make their influencers disclose properly, that they still face potential federal court action, or certainly administrative action for violating FTC law, and possibly even having to pay money.
Wow. So there's definitely consequences. And the thing is that, I think as we've just gone over here and confirmed, there are ways that you can comply, that aren't big and scary, that can be kind of fun and reflect your personality, and yet meet the FTC guidelines. So, I think that that's just important for everyone to keep in mind, that you need to do this. It protects you. It protects your merchant or advertiser, whoever it is that you're working with. It helps your consumer to understand better what the offer is that's being shared with them. And, and we can just keep going on our merry way. I think
in the affiliate space, the FTC has brought a number of cases and gotten a number of settlements with affiliate networks. Like AWin. AWin has, it's not one of those, fortunately, because it's a very compliance conscious network, but it has sued and gotten settlements and a lot of money from affiliate networks whose publishers were doing bad things.
Right.
Driving traffic to the networks of merchant clients. And
yeah,
so
a lot of those were kind of along what we would more traditionally call CPA networks. So ones where it's kind of lead generation or continuity programs, things like that. And kind of sad but true, because of some of the stuff that they pulled with fake testimonials and things like that. That's part of the reason why the FTC now has to kind of watch the entire industry in general.
Correct. It only takes a few bad apples to spoil the entire bushel.
Yes.
And
unfortunately. So.
But this consent this past September with these prominent social influencers, Trevor, Tamar, Tim Martin, and Thomas Syndicate Cassell, who were working for an online gambling service called CSGO Lotto, is sort of a shot over the bow. As I said, it's the first FTC enforcement action against social influencers, but it won't be the last. And so, and again, as a general rule, the bigger you are, the more prominent you are, or the more visible you make yourself, or the more audacious you are in your public profile, the more likely it is that you'll get on the FTC's radar and become a target if you aren't complying.
Okay. Well, that sounds good. I think we've covered everything now, and we've answered all the questions that have come through. So, Bill, I would like to thank you so much for all of your time and your knowledge today, because it feels really good to get it right from someone who knows, who's been inside the FTC offices, knows how they take a look at things, so that we can make sure that we're compliant and continue on, without kind of having any issues with our industry. So, yes.
My pleasure, Janine, and thank you all for taking the time to listen to us today.
Absolutely. Thank you, everyone, for joining us today. This will be made available on YouTube, so if you want to hear it again or share it with someone, we would be more than happy to have you do that with us. Thank you so much, everyone, and have a wonderful day. Bye-bye.